Welcome to the Seattle Real Estate with Urban Ash, your go-to podcast for all things Seattle and Seattle real estate. Whether you're a first-time homebuyer, an experienced investor, downtown resident, or simply just curious about the latest market trends, we've got you covered. I'm Urban Ash, a 20-plus year downtown resident and real estate professional. Together, we'll uncover insider tips, share expert insights to help you navigate the market, and showcase community leaders and organizations. So join me as we dive into everything from the rental and sales market to the rich community life that makes Seattle so unique. All right, what do you say we roll, Rebekah?
Sounds good. I'm ready if you are.
All right, cool. All right, like I said, thanks for joining everyone today. We've had some changes kind of in the works for our HOA laws for Washington State. And so as Rebekah has been such a great resource throughout the years for not only kind of our condo market here in Washington, but other states nationwide. And she's really great at kind of breaking down the different issues, risks within condo HOAs and boards, and really studying them in great depth. And a lot of it is all about the data that she's kind of put together in kind of a proprietary way. And so I love to lean on her for any sellers or board questions, even with my own board in downtown Seattle. There's always things that come up, and whether it stems from your declaration, or it comes from amendments or just the change in laws in which we're talking about today, every year something new is happening, right? And so it's great to have just a resource that watches those things and then also consult sellers, homeowners, boards, and then as well as buyers. So like a part of our buyer package, when we're working with buyers, Rebekah's there going through all the HOA documents, and it just gives such a sense of release, I think, a relief for buyers to know that there's someone out there kind of able to dial down 400-page documents into an hour Zoom session. So being that we have all these new kind of laws on the horizon, and I've even seen the shift with our board and how we're going to be doing things starting this year with our simple board meetings and reporting and disclosures to everyone in the building and all that, felt it was very appropriate for us to meet this morning and kind of chat about those things so that people could kind of start thinking about them if they're a part of HOAs or looking to be a part of them this year. So thank you, Rebekah, as always.
Thanks for having me. Happy to be here.
Yeah, good. So we could just kind of start off with maybe, do you want to talk a little bit about the common interest community a little bit and what exactly that is and kind of the HOAs for those that might not know, just kind of simply put it?
Sure. Yeah, the terminology has changed a little bit, and that's part of the intent of some of these statutory changes. So with our newest state law, that took effect in July of 2018, and that's the Uniform Common Interest Ownership Act, UKIOA, or some as Washington Uniform, we call it WCIOA. And that was the first major shift in statutes since 1990 when the Condo Act took effect. So we're in this really interesting shift where the Condo Act still is in effect. The Horizontal Property Regime Act before the Condo Act still applies to condos formed before the Condo Act, but then parts of WCIOA apply to everybody. So there's a big shift in that legislative application because we're moving towards this Uniform Common Interest Ownership Act. Starting in Jan 1, 2028, that full law will fully apply to all associations in the state, regardless of whether you're a condo, a townhome with an association, a beach community, a homeowner association of single-family homes that's not a condo. Now that's all going to be under one umbrella of state law. But in the meantime, as we get there, it's kind of rugged out there right now with the different laws and how they apply and which ones apply and who got the memo and who didn't. And then there's a fair amount of confusion in the application of those laws. I see that frequently. I got a call the other day from a homeowner who was asking about the new law about meetings. And meetings, the new law requires that homeowners be allowed to comment at the beginning of every meeting. That's a law. Well, she called me and asked me, does that law say I can't comment any other time? I said, no. So then now that law is being interpreted that the only time the board can take comments is at the beginning. So it's intended to protect the board so that there's not disruption throughout the whole meeting. But it doesn't mean you can't. If the board wanted to take a question, they could. But so people were saying, well, the law, this particular association read that law as we can't. We can only allow you to speak at the beginning. So there's going to be a lot of that turmoil as these laws change and people figure out what do they mean, how do we apply them. But hopefully in 2 years, one law will make it easier. Right now, it's pretty messy, and some of the scenarios are really messy.
Yeah. Why are we seeing a lot of these changes? I mean, every year something has happened. And so is there something that you're seeing trend wise that is calling for these changes, specifically for Washington?
Yeah, yeah. And Washington, when they passed Wakiowa in 2018, the last few years, it's been incrementally taking pieces of that law and saying now it applies today to everybody. So that's part of these big shifts is every year we're saying, well, wait a minute, we're going to take this part of Wakiowa that will apply to everybody, but we're going to make this apply to all condos now. So, for example, one of those statutory applications is the reserve study requirement that applies to all condos in the state. And some haven't gotten that memo. They're still assuming that they can opt out if they're 10 units or less or whatever the Condo Act said, but that isn't true. So it's messy because of the transition, right? Where we've got these old laws that everybody's been operating under, new law, some of it applies, not all of it, half of it does, half of it doesn't. And so that's kind of incrementally rolling out.
And I think you kind of touched on it too. And what we notice in our market is we have a lot of these single family condo projects, right? Or townhomes that are maybe 2 units or 3 units, right?
Mhm.
And so those owners have to, when they're purchasing, and we just had one actually last week, where it's a 3 unit, and that owner is coming from a house and she's buying into new construction townhome that's a condo. And so there's 3 people that are going to be sitting there on that board, and they're going to have to figure out all the laws for, being condo owners.
Correct. Yep. And that's interesting too, because they're looking at releasing some of that obligation for small associations. If there's only, and that's one of the statutory requirements or changes that's occurred, is the ability, and this is most related to conveyance of real estate. So the statute now says if you're an association, if you live in an association and you're selling your property and you're supposed to provide a resale certificate, well, if there's never really been an association, if there's no real impact, now they can opt out of that. So I think that will definitely show up when we look at some of these 2 or 3 unit condos where they don't even act like a condo, they don't live like a condo. The only reason they are is because they couldn't split the lot to put 2 units on this lot. But other than that, they have a utility line, but very little exposure. So I think under that new law, some of the communities that struggle with some of that effort will be relieved from that. Like they won't have to. So we'll kind of see that shake out. And we're seeing that start with the resale certificate. And they're also, I'm not sure if it went through or not, but there's discussions around releasing some of those smaller units from the statutory construction defect warranty, the implied quality, or the oh, the statutory warranty that protects condos.
Yeah.
So they're thinking of relieving that for these small communities. So there's going to continue to be shifts around the different style of communities. The big difference under the new state law is they're all treated as similar, one law. Doesn't matter if you're a condo or a townhome community that's not a condo. Same laws apply.
Same laws, yeah. Um, Now that you touched on resale certificate, and that's a big thing in my world with, the resale certificates being prepared and putting everything together for buyers to review. And from a standpoint of a buyer purchasing into, let's say, this townhome community or whatnot, it's very important to stay on top of how you're reporting, how you're documenting, and how you are overall governing, I think, the boards. Because you want to show strength in a history when you go to sell that property to a buyer so that the buyer knows kind of what they're getting exactly. You want to just touch on basics of the resale certificate real quick, just for people who might not know?
Yeah, so currently we have 2 state laws that govern resale certificates. There's all condos formed before the Wakiowa or those that haven't opted into Wakiowa. So we used to be able to say, okay, if their declaration was recorded before 2018, they're automatically under the Condo Act. Well, the state gave those associations the ability to opt in to WCIOA. So some of those communities formed before 2018 are now fully subject to that different resale certificate statute. So it's caused a little confusion out there. And then because there's two different laws that apply to two different time periods, one of the concerning things we're seeing this year is several management companies have decided we're going to provide resale certificates that comply with WCIOA, all of them. And that doesn't work. I mean, they can do whatever they want, but what that does is present a risk to the seller because the seller then is not providing a resale certificate that complies with the proper state law. And that gives the buyer the ability to walk away up until conveyance because they haven't received a complete resale certificate. And the differences aren't significant. There's not a huge difference between those two state laws. WCIOA's resale certificate requirement, a couple good things is that it does specifically require meeting minutes be provided. The Condo Act didn't. So now if it's a WCIOA community, they have to, by law, provide 12 months of meeting minutes. So that's a good shift is we want to be able to get that information that buyers want to be able to determine what are they buying. Another good shift under WCIOA, which nobody has gotten the memo, is sellers don't have to sign it anymore. There's no requirement, but they're still doing it. So we could take that, whole effort out of the way. So I think over time, those resale certificate, well, under WCIOA, having one statute will definitely help with that. Right now, it's really messy because so many communities are suffering from the management company's approach, which several of them out there aren't complying with the state law properly. So we'll see how that goes.
Yeah. And so then within the research certificate, and you touched on reserve study, are there any major changes or around that, like reporting? I think you touched a little bit on it, but I just
No,
want
the reserve study is still required. The difference is under the state law, not related to resale certificate, but prior, the Condo Act said there were a few specific scenarios where associations could not be required to get a reserve study every year. State law says you have to get a reserve study every 3 years from a reserve professional and an annual update. WCIOA now says it says the same thing, but the difference is there's a more defined parameter for opting out. And it's now if the association only has nominal reserve expenses. So now we have to define what is nominal, a little bit of expense like a sign, an entrance gate. And then the other requirement to opt out, what was it? Nominal, or if the cost of the study is more than 10% of the total annual budget, which if reserve studies are $1,500 to $3,000 ish, that leaves the really small ones opting out. But pretty much any kind of reasonably sized community still is required to get reserve studies. But most of them, the law also says there's no penalty if you don't. So that's a good one.
So if you, for buyers and sellers, then the new laws, what do you think is going to be the most impactful going into 2020, this year and into 2027 and 8? What are the ones that they're going to have to look out for?
I think the resale certificate law is definitely incredibly impactful to buyers and sellers. That's the most impactful part of the statute because that's the law that says here's what sellers have to provide and here's what buyers have the right to receive before they make a decision. And until the buyer receives everything they're supposed to, they can walk away with no penalty. So there's a lot of incentive for the seller to provide everything they should. And what part of that challenge has been is the seller doesn't have access to all that data necessarily, and they rely on the management company to provide it. Well, this is going to be significant if this Senate bill goes through, which it's currently in the House. It's made progress. There seems to be a lot of support. I think this is going to be incredibly impactful. And I'll just read a little section of it. They're adding to the WCIOA resale certificate statute, if this goes through, they're saying that an authorized agent, management company that charges a fee for furnishing that resale certificate assumes all liability for the fees charged for the timeliness of delivery, accuracy, and completeness. And then they've also added in the law, which if it goes through, in the unit owner, the seller, if they order a resale certificate and it's not complete, then that seller has a right. The court must award reasonable attorney fees and costs and actual damages to any prevailing unit owner and may also impose a civil penalty against the association or its agent responsible for delivering that complete information. So if we keep seeing these resale certificates that are incomplete, incorrect, don't have the correct information, which still out of the last 500 I've done, I'd say maybe I got five that complied with state law. So now there will be recourse for those sellers who are trying to sell their unit, can't get the information, paid for a resale certificate, it's incomplete. Now there's some leverage to force that to be correct, which I think is going to be
Yeah.
significant.
Yeah, that's great. I mean, it does put the onus on the management company to kind of do their job in which they've been hired to do anyway.
Correct. Correct.
And then does kind of empower the seller or homeowners to make sure that they're getting that information. So it does make sense. It kind of protects everyone.
And it should be theoretically, it should be easy-ish,
Mhm.
right, to do that. So, for example, if the new state law requires meeting minutes be provided in the resale certificate, well, the new state law also mandates that boards only do business at meetings. Now they can't do business over email anymore. Now they can't meet in the hall and agree to sign a contract and go sign a contract. So that leads us to the meeting should be structured now under law. Therefore, we should easily have meeting minutes available. Like it should match up.
Yep, and that does, I mean, that tracks with what our building is going through too, in terms of, everything being maybe more transparent.
Yes.
Because you are more in these structured meetings and everything is being talked about and
Yes.
so it does probably trickle down and benefits everyone for sure.
And it'll lead to longer meetings,
Yeah.
more work to do it all at once. But hopefully, if we can do everything at a meeting, then boards don't have to do business every
Outside.
day, all day outside of those meetings. That's
Yep.
kind of the intent. So, there'll be a shift, but hopefully that shift will lead to more clarity for purchasers, which is kind of my focus. Is if the law says here's all these things that must be provided, let's provide them.
Yep.
Let's
Yep.
get them.
Is there anything else that you're seeing in terms of the changes in the laws or for buyers, sellers, homeowners to kind of be aware of?
Well, definitely you touched on it. The meetings are a big one. That's significant. That is a massive shift in state law to mandate that boards only do business at meetings. That one is significant, not only from a time perspective and just the agenda length of business to be done, but it will give owners a much better ability to be aware of what's happening. I think that's incredibly significant. We'll see how it affects boards, whether they like it and want to continue to serve voluntarily and
Yeah.
do the work, or if it ends up being, a burden and nobody wants to be on the board. I don't think that'll be the case, but
Yeah.
there are some communities where it's really hard to get board members involved and engaged. It's work. It's a free part-time job.
Yeah,
I
you have to be passionate about it for sure.
Yeah, and I tell buyers, when you go into an association, obviously the best way to protect yourself as an owner is to be on the board. You have the most knowledge, the most access to information. And I tell people, think of that like your part-time job that you get paid for when you sell it. If you participate and help it be successful when you sell, you'll make more money.
Yeah.
So I think that's the biggest one. I think that's the most significant. Another one that if they, that could be impactful, it depends on where they cut the level for not being able to pursue for construction defects. If they limit that implied warranty of quality in the law, will it be at 5 units, 10 units? Will it just be for those two or three? I think that'll be interesting because I know you've seen how much new construction townhome style communities are out there.
Yeah.
And if they don't have that statutory warranty protection for buyers, then we're going to be right back where we were before that law took effect, where they're not building them properly and they're going to be leaking and,
There's no
not,
recourse.
yeah,
Yeah.
yeah. So hopefully that'll be cut off in a smart way.
Yeah.
Because I do think that the 2 or 3 unit condos, there's not much risk there. There's not a whole lot of construction defect risk that
Yeah.
will show up.
That's true. I mean, we do want to protect our developers too, who are sticking their neck out and building this
Correct.
housing and supporting kind of the zoning changes and stuff to create, more kind of the urban lifestyle for, neighborhoods like Ballard specifically,
Yeah.
which I think we've seen a lot of that happen. And so, I see that, but also you have to protect the consumer, the buyer, and be able to kind of stand by your product that
Right.
you're
Right. And a
releasing.
lot of them aren't, another big impact for that with the construction defect issue is that they're not stacked. There's less risk of flooding neighbors below. There's very little exposure from a construction standpoint to each other. And now we're seeing a lot of those 2 or 3 unit ADU dadu condos where they used to have the 1 and 2 units like share a whole wall. Now we're seeing them share a shed wall, like almost as minimal a connection. So they were figuring out, developers are figuring out how to work around some of those issues. But I love those condos. I think they're a great option. There's density, they're low exposure, they're available, and they're less expensive, of course, than a single family home. So I think those are great.
Yeah, definitely. Um, Let's talk about just in general the health of the boards that you're seeing right now and any from the time of maybe how COVID impacted HOAs and like from where we're at right now. Because it's been last 5, 6 years have been a lot of turmoil, I think, between and mainly budgets, right? And with
Yes.
all the things. And so let's talk a little bit about that. I know and if anyone has questions specifically, I think you should be able to pop it in the chat or we'll address them at the end.
Yeah, happy to take questions. That's helpful. Um, Yes, definitely. Gosh, looking at the cost increases, the cost of doing business, and therefore your association dues, maintenance fees going up significantly during and post COVID and with inflation. Going into 26 so far, I would say if I just were to pull 50 that I've looked at so far in 26, I would say at least 45 of those insurance expenses have come down significantly. So
That's
we're
right.
not budgeting, and that's also a reflection of budgeting, right? So if we're budgeting for next year, we're going to kind of budget in a conservative way, and then hopefully we're under budget, for that amount. So now we're seeing that the last cycle we had to everybody had to budget at a pretty high level for those increases in insurance, which some were just insane. Now I'm seeing that plateau and come down a little bit. So I've seen probably also out of, if I were to pull that same random 50, I bet at least 10 of them have reduced their dues this year, which I don't really like to
Wow.
see that.
Yeah. Is it because maybe they over budgeted the year prior for insurance
Yep.
because the hikes were so high and so they kind of yeah.
Yes.
All right, gotcha.
Yeah. And of course, if I could tell anybody anything, just keep them flat. Don't reduce it, just don't increase it.
Yeah.
And then whatever delta you're saving that year, if insurance comes down 50 grand, put that 50 grand into your reserve.
Mhm.
What I've definitely seen coming out of this cycle of uncertainty and crazy costs is the communities that continued to operate conservatively during the good times did better during these awful times than the ones who didn't raise their dues for 5 years, didn't meet, didn't do anything. COVID hit, their dues went up 100%. Like some of them did go up 100%. That's an exaggeration, but they went up significantly. So if I could talk to all associations, I would say in the good times is when you have to really pay attention because at some point that's going to turn and something's going to happen. The financial collapse, COVID, something else will happen, regulatory, and then, the ones that didn't prepare will get further behind.
Yeah.
So I did see that. I definitely saw that when looking at age of construction, the really old communities that kind of hadn't quite done all their rehab work or their renewals, they really got hit hard. The ones that did their full strip and reclads or their elevator modernization in like 2018, 19, thank God they did because they would have paid double later.
Yeah.
So it's really fascinating to see how that timing for renewals, how critical that is, and the associations that follow that and take care of it on time when they should don't end up suffering. Duh.
Yeah.
Some of the ones that didn't, boy, they really got hit hard.
So I know that with that, there's always concern from a buyer standpoint or people kind of looking at, well, the dues are so high in that building. And we always are constantly having this conversation that high dues actually it does not mean it actually is a good thing,
Yes,
right?
it can be for
It can
sure.
be a good thing,
Yes.
right? And you don't necessarily want to walk into a building that has the lowest dues because you should be aware of how if the board is being run conservatively, if they're actually looking at what is budgeted for the future in terms of all the things that are on the reserve study and then also, just different maintenance projects. Um, Anything to add to that?
Totally. I mean, when I compare the data, which is
Yeah.
the fun part for me. Well, there's a lot of fun part, but looking just purely at data, if you pulled 10 buildings that had the same number of units, same general age of construction, the difference in their monthly dues would typically be how much they choose to contribute to the reserve account. Everything costs us, utilities cost the same, insurance costs about the same with some variables, age and risk and all that. Management about the same. So when you see, if you looked at 10 properties that were all similar and one had really high dues, hopefully the reason their dues are high is because they're putting a lot of their budget to reserves. What sometimes flushes out in that data in a bad way, I saw a few times their dues were really high because their insurance was insane. There's a historical building downtown who's in the middle of knob and tube electrical replacement and plumbing replacement. Well, their insurance went up 200% until they get done with that. That's why their dues went high. But when they're done, they'll be back down to what everybody else is paying. So yeah, high dues are sometimes a good thing. And I view that also the reserve contribution, I almost wish they would call it the depreciation contribution, which is a way to help illustrate that people who live there should be paying for the deterioration as they go. So if you have a high reserve contribution and high dues, that means everybody who lives there is paying for their share of the roof instead of whoever buys it gets the hot potato and pays for all of it.
Yeah, about what is the rule of thumb for what you should be contributing toward?
Oh gosh, good question. It definitely varies by construction style.
Mhm.
I like to see townhome style communities, and I call those sometimes wood frame walk up, where there's 3-story wood frame, no elevators, no hallways, no corridors, 10 or 12 buildings, stuff like that. I would say 35 to 40% of the budget is usually kind of a good target. High rises generally 18 to 22% of the budget. And that can really be skewed based on their management scale. Because with high rises, the biggest cost is management and personnel. It's the largest part of the budget. Instead of others, the reserve is usually the largest part of the budget. And then mid rises, 25 to 30% ish is usually a really good target. That's a good baseline to look at. And that's a frustrating data point because the reserve study doesn't tell you that. You have to go figure it out. How much of the budget's going to reserves? Like, I view that as one of the most critical data points. And it's hard, it's not easy to find that
Yeah, and a lot of
quickly.
the time on the reserve study too, they give the graph of the risk is high, the risk is low, and that's the first thing that buyers and or agents look at, right? And it's not a true measurement to actually what is going on within the HOA. And yeah. So
It's so frustrating.
yeah. Yeah. And on a Mac, I think that that's where also sales or transactions get killed because like it's like, oh
Totally.
no, it's too risky, but they don't take the time to actually dive into how much is being funded, towards the reserves. What are the maintenance projects? Why might the insurance, just like you said, a building goes through a period of time which insurance goes up until they update their systems. I mean, those are all things you really got to dive in and actually know what's going on because the buildings are their own little ecosystems themselves.
Yes, and those reserves, the percent funded is the bane of my existence practically. And I don't like it. I think it's a terrible measure. I looked at one the other day. They're 49% funded, except they need to do a full strip and reclad this year. I looked at one that's 12% funded. They just did their full strip and reclad. They're good for 20 years before they have to kind of deal with a bunch of stuff. So I find it really frustrating when I see brokers and buyers walk away from a property purely based on that red is high risk of special assessment. Well, it might be high risk of special assessment in 25 years, or it might be high risk of special assessment tomorrow. So that timing for repairs is the most critical, not the percent funded.
Yeah.
When do those repairs show up?
Or the people preparing the reserve study need to change their reporting matrix.
They do. And what I would love to see is, reserve studies have to look at a 30-year time period. That's what they should do. Well, I think what they should show is when in that 30-year time period does that risk show up? Is it in the first 10, the second 10? Is it in the third 10? Because you can see an association that's very low funded, but they've got 25 years before they have to redo everything. So that would give a buyer, great, I'll take this one because I have very little to do for 10 years, as opposed to one that might be higher funded, but they've got to do a full strip and reclad in the first 10, as opposed to, the last 10. So yeah, I would love to see that shift. We'll see. Probably not. It won't ever happen, but I would love
Yeah.
to see it.
The other thing that whenever we talk about kind of new constructions or building that were built a little bit newer, to buyers, you always kind of give this time period in which is like the optimal type. Could you share and talk about that a bit?
Yeah. Yeah. The cycle of construction, right? So when you talk about timing for things, components generally have specific timing for age of useful life and when it's time to do the work. So I see new construction, and if we're talking towers, towers generally what I see in the data is by the time they turn about 8, maybe 9 or 10, now with some delays in getting through construction defect, a new construction tends to be a little unstable until they get through the construction defect process and figure out what's the issues we need to resolve with the building. How much do we really need to contribute to reserve account? How much does it really cost to run the building and fix, just live in it? So by the time buildings go through their construction defect, litigation, resolution stage, it takes a year or two, sometimes longer, to resolve all those issues they litigated for. And then you tend to see kind of a sweet spot of about 8 to 10 years where kind of nothing happens. We just solved all these massive problems. We've dialed it in. We've fixed everything. Our funding's in line. We don't have much to do until it's time for roof replacement, typically year 20, 25. And then many buildings don't have enough money set aside for the roof. So that's our first round of, well, let's do a special assessment or a course correction. And then you have another lull. About 30 years is elevators, HVAC, mechanical stuff, all the way in between all of that. So there's definitely patterns in timing. That was towers. And then wood frame construction, of course, you end up with full strip and reclads, time for new siding, windows, typically around year 40. So there's definite, timing gaps. And that's why I kind of like the 10-year cycles,
Yeah.
because it is 10-year, 20-year, 30-year, 40-year components that, with a lot of variance in there. But it helps kind of predict where do those costs show up and when.
Yep. And so for a buyer also who's maybe looking to enter, during those major cycles, with special assessments, if there was a special assessment, typically that's a great time for a buyer to get into a building because the seller's paying that off, usually in negotiations of some sort, depending on how that is. But then they're walking into a whole new life cycle of updates and things that have already been done. So actually, I think a lot of buyers tend to say, "Oh, I want new construction because I want maybe even lower dues, or I want to not have the headache of any special assessment." But that is not necessarily the case.
That is true. Yes, I definitely see that. I just did a review recently for a property that in 2019, they did a full strip and reclad and they just finished replumbing. Well, buy that one. I mean, there's nothing left. Now it's just painted in 10 years and redo the roof in 20. Those are gold. So I love, and when I talk to the brokers and teach classes, find the properties that have a special assessment in place. The risk is identified. The work is either done or going to get done, and the seller typically pays for it. So those are the best because, with any purchase, it's risk. What's your risk? Well, if we can identify the risk, we love that. And
Yeah,
special assessments definitely identify the risk.
definitely. Let's kind of take a nationwide look, I guess, at where Washington sits in terms of the laws versus other states that you've worked in.
I feel Washington definitely has robust state laws. Maybe I'm not sure if any other states have more enforcement mechanisms. I think lots of states have laws. I don't think any states have much mechanism to enforce those laws. Just like before, if this statute modification around resale certificates doesn't go through, there's no recourse to make the management companies provide a resale certificate. What do you do? Individual unit owners would have to sue them, which no one's going to. So I feel Washington, and for sure on the construction defect side, we have very robust laws for protecting that, and primarily because of the water related challenges. It rains a lot. Most states have some form of, states that I've done business in, most of them have reserve study requirements. I see that as well, where there's not much enforcement. You're supposed to do it, but nothing's going to happen if you don't. So I would say Washington is probably one of the leaders just in the states that I've done reviews in. I think I've done 15 or 20 different states. I think Washington's resale certificate requirement is definitely very robust. Oregon doesn't have one, which
Gotcha.
on the flip side, it's kind of bad in a way. Like some states that don't have resale certificate requirements, all the information you want is on their website for free. You just go download the minutes, download the budget. It's
Yeah.
all there for free.
I'll say, even working in Arizona, how Washington is definitely more structured. And when you're ordering a resource certificate package from the management company, or you're getting a Form 27, you have specific questions that need to be answered, and you have an actual structure. Whereas I think in Arizona, you have to go digging for the information, and it's almost like it's not something that's readily just provided to you. It's like you're in
Right.
contract, and then you're getting it from the title company, and then it's just very disorganized. And so I
Yes.
do wish sometimes down there with our condo buyers that we had more structure to that, because I know that it would just be more helpful for everyone, and then especially you for doing the reviews down there too for
Yeah,
us.
it's kind of a nightmare and a blessing.
Yeah.
If and then the way to fix it would be everybody has one form to fill out. Here's the resale certificate form for a condo sale in Washington state that must be used. This form. And that would solve like 99% of the problems
Yeah.
because everybody fill it out the same way.
Yeah.
Because every management company does their own thing. They have their own forms. Their forms don't match state law. We have these independent companies that deliver the HomeWise, condo certs. Their questions and answers don't match state law. So yeah, we have these laws, but that's not great if no one can follow them,
Yep. No, I
if
hear
no one follows
you.
it.
Yeah.
Let's make more laws.
Yeah.
Well, great.
What, just for fun here, and we're going to probably wrap it up here in a few minutes. So if you do have those questions, plop them in the chat. But what is like the most nightmare, bizarre thing you've seen within either the board or reporting on a resource certificate, or a situation that you've seen kind of arise?
Oh, well, I don't want to say the best ones, but I would say the most in kind of fun ones to read are the ones where the homeowners have lost their minds and are suing everybody because they're mad that they have to pay for something because they don't think that's right. The board's hiding stuff, or I see a fair amount of that.
Yeah.
Um, let's see.
I mean,
I looked at a 4 unit property, and they had one owner that was like, it was amazing reading what this owner was upset about, and they had to get a court order that wouldn't allow the owner to keep knocking on the board's door and slipping notes under their doors, and like crazy harassment.
yeah.
So that's sometimes interesting, is what are the crazy homeowners who, there's a few out there, right?
I mean,
And how do they
ultimately,
impact?
in every community, there's a few of them.
There's always a few.
Right. And, and again, the transparency and the structure of, like, the new laws that are coming in, does that help with that? Right. Because it's like, or is it just the person, and you can't
It's
control that person
people.
anyway? And it
You
is
can't
people. Vertical living, and you are living on top of your neighbor. And so it's,
People are people. You can't make laws to make people not be people. And there's going to be some crazy ones, and they can't help it. They are what they are. They can't help being crazy. They don't even know they're crazy.
yeah.
I did also look at, their property that I've been watching. I've been watching to see what will their special assessment end up being. About 8 years ago, they were tossing around a $3 million project that never happened, and then all kinds of crazy stuff. And now here we are, $10 million, the number they're looking at. And I just knew it was coming, like it was going to be crazy, and it
So
was.
what was that based on, like deferred maintenance stuff, or yeah.
Mhm.
Okay.
Yep. Yep. And there was some mess in there with the board and the board president, who I'd kind of been watching, who was also the board president at another high rise. There was some mess. So that sometimes you can kind of see happening. Well, I can just because I look at so many documents and over time and see how things progress. But I think the fun part for me is when I see a community come out of something successfully.
Yeah.
And now I can tell a buyer, great, this is the time to buy, instead of, you better wait and see, or you might want to wait and see what happens here.
Yeah.
So I have seen a lot of success stories too, where the communities go through these full strip and reclads, get the work done, get a loan, do the work, the values go back up, and then they sell. And then it's just the turnover, rinse and repeat. So yeah, there's definitely some fun ones to that aren't just the same old boring doing great.
Yeah. Well, good. I know we can nerd out all day about condos and boards and everything like that. So, but I think that thank you so much. I think we hit pretty much all the different things that we
Yeah,
wanted to.
thank you.
And for those watching, I know you didn't have any questions today, but if anything does pop up, feel free to reach out to myself or Rebekah. Will post this on YouTube and have it available to rewatch. And if there's any questions about your specific HOA or building or whatever, feel free to use Rebekah or myself as a resource just to make sure that you're moving forward in yourself and or your community. So good. Well, thank you so much, Rebekah. Always a pleasure. Thank you,
Thanks for
everyone.
having me.
And, yep. Have a great
Same.
Friday and weekend.
You too. Bye, everyone.
Bye.